2022 CR 8453, State of Texas versus Mark Daniel Lewis. Can I have parties announced for the record for the state?
Hank Wilkins with the state, Your Honor.
Defense.
Ed Piker for Mr. Lewis.
And are you Mark Daniel Lewis?
Yes, Your Honor.
I'm showing you what's entitled motion to revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Mark Daniel Lewis who is placed on community supervision in 2022 CR 8453 for the offense on unlawfully carrying a weapon with a felony conviction on January 13, 2023 for a term of 10 years? Is that you?
Yes, Your Honor.
State?
Honor, violated condition number 15G, on or about the 26th day of May. And Judge, I'd like to orally amend.
Oh, just one moment. Excuse me. Could you, if you all could move to the other end. Okay. All right. Are we proceeding on the motion as presented, State?
Judge, we'd like to orally amend. I've conferred with defense counsel. We'd like to orally amend the year. It should be May 2023 instead of May 2026, Judge.
All right. Any objection?
Judge, I confer with my client on that and we have no objection.
All right, Mr. Lewis, do you understand that that's a substantive change to the motion to revoke?
Yes, Your Honor.
Do you understand that your attorney has 10 days to prepare for trial?
Yes, Your Honor.
All right. Did you wish to proceed?
Yes, Your Honor.
All right, State.
On or about the 26th day of May 2023 in Russ County, Texas, the defendant, Mark Daniel Lewis, did then and there fail to comply with the rules, regulations, or instructions.
Excuse me, just one moment. Were you changing that date?
Yes, Judge, to 26th day of May 2023.
Okay. All right. Thank you. Sorry about that.
Sorry. In Russ County, Texas, the defendant, Mark Daniel Lewis, did then and there fail to comply with the rules, regulations, or instructions of the Bexar County Community Supervision and Corrections Department Substance Abuse Treatment Facility, in that the defendant was behaviorally discharged from the East Texas State ISF unit in Henderson, Texas, in violation of condition number 15G.
How do you plead to that? True or not true?
True.
All right. Did you understand by pleading true to violation 15G, the court could find it true, grant the motion, sentence you to 6 years in prison?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of 15G?
Yes, Your Honor.
Court will find violation of 15G true. Is there an agreement?
Judge, we don't necessarily have an agreement. I have no objection. The defense counsel has spoken with probation and we've conferred. And I think he has a proposal that he'd like to make to the court that the state has no objection to.
All right, Mr. Piker.
That's correct, Judge. And then I will call my client because he knows better what happened than I could ever tell you.
All right, Mr. Piker, what are you requesting?
I am requesting that the court consider keeping him on probation, not revoke him, and move him out of, don't revoke him, don't send me back to that facility and send him to lifetime recovery. We've looked into it. It's a 3-month residential. He's motivated. Actually, it was his suggestion that if that was possible to get him out of there, he wants to help. He wants to get off the drugs, but he can't do it where he's at.
Okay.
And he is going to explain that to you better than I can.
All right, Ms. Abrams.
I apologize. I cannot hear.
On this case, it is Mark Daniel Lewis. There was an incident at Henderson, and he wants to, his attorney is suggesting that he be placed in inpatient at lifetime recovery.
Your Honor, probation would not have any objection.
Okay. And so that I will know, what is the issue with that facility? We'll say allegedly.
Would you like to hear it from me or from Mr. Lewis?
Either one.
Mr. Lewis can explain it better than I, but I will tell you that he was in a gang. He was in a gang when he got there. He wanted out of the gang. He told him he wanted out of the gang. His life was threatened. His well-being was threatened. And quite honestly, from what he tells me, there was so much drug usage there and fight night that it was not conducive to getting better. It made it worse.
All right. And this is at the facility in Henderson, Texas?
Yes, ma'am. He will swear, he will tell you that under oath.
Oh, no, I'm going to make sure that the facility at Henderson, Texas, that we do, that a spot check is done, random, so I can figure out what's going there, because the last thing I want is someone who's trying to get treatment and wants treatment to be sent to a facility where it's difficult to receive that.
And that's why I wanted him to address you, because I knew you'd be interested.
All right. You want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name.
Mark Lewis.
All right, so tell me what is going on at the Henderson facility?
Whenever I was here in this courtroom on January 13th, I signed for the 10 years probation. You gave me the choice to go receive help or go to TDC where, so I chose the help. And whenever I was finally transported to Henderson, Texas, I threw myself into the program and I started learning about thinking errors. I started learning all the aspects I needed to learn for my first track, which was cognitive intervention. And I had a very successful 45-day call. But during that time, I made the decision to step away from the gang affiliation that I was affiliated with. And I made it known that they were doing fight nights. There were people out there still smoking K2.
Fight nights?
Yeah, it was disrupted. The counselors would come in and they would read from a piece of paper for an hour and they would leave until the next day. And it was back to the same stuff. And I made it known that I didn't want no part of any of that anymore. I was trying to get back to my daughter. I let everybody know, like I was back in my Bible. I was trying to get myself right. And a lot of people took that offensive and they threatened me and they were trying to jump me. And thankfully the guard was able to see that something was going on and they pulled me out of the dorm that I was in and they placed me in a single man cell in restrictive housing. And when they came, they were like, they wanted to send me back to that environment. And I wasn't trying to go back to that environment because of the threat. And they said that by refusing that environment, I was refusing the program. And I knew that I would have to come back here and address you, but I'm trying to do better.
Okay. No, I appreciate that. So what I'll do then is I'll deny the motion and I'm going to alter and amend conditions to include lifetime recovery, the inpatient, and you'll be transferred from the jail to lifetime recovery.
Yes, Sean.
All right. Is there anything else?
That was it.
All right, we can go off the record. See what I mean about communication being key? If I don't know this is going on, then, but thank you so much for letting me know.
Thank you, Your Honor.
You didn't get any more tattoos while you were there, did
No,
you?
thankfully not.
Okay.
Thankfully not.
And he's not from Indiana.
Okay.
Okay.
All right.
All right, thank you, Your Honor.
Thank you for letting me know.
This is the kind of courtroom moment that reminds you why communication can literally save a life. What started as a routine motion to revoke probation was moments away from becoming a 6-year prison sentence for Mark Daniel Lewis. On paper, the violation looked simple: behavioral discharge from a court-ordered substance abuse facility. In most courtrooms, that alone is enough to send someone straight to prison, no questions asked. But this judge did something different. Instead of rushing to punishment, the court listened. And what came out wasn't an excuse, it was a warning. Lewis described a treatment facility overrun with gang pressure, drug use, K2 smoking, and organized fights. When he chose to leave gang life, openly carried a Bible, and focused on getting back to his daughter, the response wasn't support, it was threats to his safety and his wife's life. That's not rehabilitation. That's survival mode. Here's the critical legal reality. Refusing to return to a dangerous environment was labeled as refusing the program. In the system, that technical refusal almost cost him his freedom. And this is where the judge's role mattered more than the paperwork. Instead of dismissing the story, the judge immediately recognized the red flag. Because treatment that increases risk is not treatment at all. Notice the shift in power. The judge didn't just deny the state's motion. She went further. She ordered random spot checks of the Henderson facility, signaling accountability beyond this one defendant. Then she altered the conditions of probation and approved inpatient placement at Lifetime Recovery, a facility focused on real rehabilitation, not controlled chaos. This wasn't leniency. This was judicial discretion used correctly. Lewis didn't walk free. He didn't escape consequences. He earned a chance because he spoke up, because his attorney communicated, and because the judge was willing to hear the truth before deciding someone's future. And here's the lesson. Courts don't know what they're not told. Silence gets you prison. Communication gives you options. At the very end, the judge says it herself. If I don't know this is going on, I can't fix it. That single sentence sums up the entire case. This wasn't a win over the system. This was the system working the way it's supposed to. One decision, one honest testimony, one judge who listened, and instead of 6 years behind bars, a second chance at recovery.